Welcome, everyone. Thank you for joining us for today's presentation, Prepare for 2023, What to Expect in Labor and Employment this Year. Before we go ahead and get started, we just have some general housekeeping items to cover. If you experience technical difficulties during this presentation, please refresh your browser or leave the meeting and rejoin. We will answer questions at the end of today's presentation. If you have questions about any of today's topics, please type your question into the chat or email Mark Newberger at the email address on the screen. I'll pause for a moment so that you can write it down, or it's also within the chat.
Thank you very much, everybody, for joining us in what will be our first webinar of the year in labor and employment matters. I'm Mark Newberger. I'm of counsel in the Miami office, and I will be going last today speaking about labor relations, the NLRB, and the union movement. We have a pretty packed program today. We're going to try to get a lot of different things covered. I just want to explain that we're looking at federal law today. If we were to try to predict or talk about all the various changes occurring in the various state laws, this webinar would take all day. So kicking it off today is going to be Ben Dryden. Ben is a partner in our Washington, D.C. office. In addition to labor and employment, he practices in the area of antitrust, and he will be briefing us on the proposed regulations issued by the Federal Trade Commission that would effectively ban the use of most non-competes, not only going forward, but would negate many of those that are in effect if this rule were to go into effect. Our second speaker will be Caleb Burhe. Caleb is an associate in our Los Angeles office, and he's going to be talking about laws and the growing trend of pay equity, followed by Caitlin Williams, our senior counsel in our Madison, Wisconsin office, who's going to be talking about recent legislation affording pregnant women and nursing mothers protections and some other trends that we see coming from the U.S. Department of Labor. We'll take questions at the end, but please put them in the chat as you go along, or you can email them to me as well. And with that, I'm going to turn it over to Ben.
Thank you, Mark. Thank you, Missy. Antitrust. Antitrust has infused itself into labor and employment. And so it's always a fun day when antitrust takes the first role in a presentation, but that's where we are. May we live in interesting times. So as Mark said, the Federal Trade Commission has proposed a regulation that would purport to ban virtually all non-compete agreements with employees coast to coast across the country. We're going to jump into the proposed regulation in a moment, but I think it's helpful to give two little pieces of context. First, in July of 2011, President Biden signed an executive order on promoting competition in the American economy. And this was a very broad executive order. It had 72 some odd directives directed to over a dozen federal agencies, directing those agencies to take certain actions to promote fair and free competition in the United States. One of the headlines of this executive order is excerpted on this slide. The president directed the chair of the FTC, and I should say the FTC is a 5-member commission. It has 3 members of the party in power. So there's 3 Democrats, 2 Republicans. There's currently one of the Republicans recently resigned, so there's only 4 members. But the directive called for the chair of the Federal Trade Commission to work with the rest of the commission to exercise the FTC's statutory rulemaking authority under the Federal Trade Commission Act to curtail the unfair use of non-compete clauses and other clauses or agreements that may unfairly limit worker mobility. And this is a photograph of the president signing that executive order, and the chair of the FTC is just over the president's shoulder. She's the second from the left, standing next to Secretary Buttigieg. She has a personal mandate from the president of the United States to get something done, regardless of whether the FTC even has this power. I should say she personally, before being named the chair of the FTC, was really the academic who was the most vocal proponent for the idea that the FTC has a rulemaking power and the ability to do things like regulating employee non-compete agreements. So she has a very strong mandate. Next slide. One other piece of context is that the day before the FTC announced the proposed rule, they announced the rule on January 5th. On January 4th, they filed 3 civil lawsuits against 3 companies alleging that those companies were violating the Federal Trade Commission Act. I should say that the Federal Trade Commission has a number of mandates. They do things like regulate horse track racing and the do not call list, but their 2 most fundamental mandates are promoting fair competition and protecting consumers. And they have a very broad mandate under Section 5 of the Federal Trade Commission Act to sue companies to prevent unfair methods of competition. And so on January 4th, for the first time ever, they'd never dabbled in this before, the FTC simultaneously sued 3 companies and at the same time announced consent decrees with those 3 companies based on allegations that those companies were violating existing law, the Federal Trade Commission Act. They were engaging in unfair methods of competition under existing law by having overbroad non-compete agreements. These were all pretty egregious cases. I mean, just as one example, there was one company based in Michigan that was a security guard company, and this company allegedly would routinely require security guards to sign a non-compete that prohibited them from acting as security guards within 100 miles of where they work for this company for at least 2 years after leaving this company's employment. What's notable about that is employees over the years had sued and said that this is unenforceable under Michigan law, and a Michigan court had agreed with them. But nevertheless, despite a Michigan court saying that these non-competes were invalid under state law, the company continued to routinely require security guards to sign these non-competes. And so the FTC alleged that, under existing law, these companies were engaged in unfair methods of competition by requiring employees to sign overbroad non-compete agreements. So that was January 4th. The next slide, please. On January 5th, the FTC carried through the directive in the president's executive order by proposing a rule that would purport to ban employee non-compete agreements nationwide. It wasn't just a proposed rule, although they have released text of a proposed rule. But in addition, the FTC had a 216-page notice of proposed rulemaking that did a pretty good job surveying the academic literature on the competitive effects of non-compete agreements. And the FTC has preliminary found, based on its survey of the existing empirical literature, the FTC has preliminary found that non-compete agreements suppress employee wages. And what's remarkable about that is the FTC found not only do non-competes suppress wages of the employees who are bound by the non-competes, but they also found that for employees who themselves have not signed non-competes, the effect of non-competes is that there's just fewer job opportunities that are open. And so the FTC has found that non-compete agreements suppress the wages even of employees who are not bound by those non-competes, which is a pretty remarkable finding. In addition, the FTC also preliminary found that non-compete agreements have the effect of raising consumer prices, increasing market concentration, and discouraging entry by new competitors. I'll interject that I think the evidence is maybe a little mixed. And there's some evidence that non-competes don't always result in higher wages, lower wages. And there is evidence that non-compete agreements incentivize companies to make investments. But based on what the FTC concluded from the empirical literature, their finding is that non-compete agreements are more or less uniformly bad. So they have proposed a very broad regulation that would just ban them across the board. Next slide, please. The proposed rule, and again, this is just the proposed rule. There's a process. We'll talk about the process in a minute. So this rule could change, but as proposed, the non-compete rules, what the FTC is calling it, would declare it an unfair method of competition prohibited under Section 5 of the Federal Trade Commission Act to enter into, attempt to enter into, or to maintain a non-compete agreement with a worker. A footnote there, the FTC at this point is only looking at agreements between employers and workers. They're not looking at business-to-business non-competes, such as a non-compete that's entered into in, say, a staffing agreement. So as proposed, this regulation would only affect the agreements between employers and workers. But as proposed, any of those agreements would be deemed an unfair method of competition. The proposed rule does not explicitly define what a non-compete agreement is, but rather adopts a functional test and looks at what the effect of the agreement is. So a piece of paper could be styled as a non-disclosure agreement, but if the effect of the non-disclosure agreement is so broad as to effectively keep the worker from maintaining gainful employment in that industry after leaving this employer's employment, then the FTC would likely say that, hey, the functional test is triggered. That constitutes a de facto non-compete agreement, which is, again, defined to be an unfair method of competition. As Mark highlighted, this proposed rule would not only prohibit non-compete agreements going forward, but would also have retroactive effect. And in fact, businesses would be required to affirmatively rescind their existing non-compete agreements. And if you're talking about a single clause in a much larger employment agreement, that would presumably require some sort of renegotiation of the agreement to strip out that clause. It wouldn't just be a matter of signing a piece of paper. I mean, maybe in some cases it would be a piece of paper, but in other cases it would be more complicated. Beyond that, the proposed rule requires employers to seek out their current employees and even their former employees to affirmatively tell them that their pre-existing non-compete agreements are rescinded and are no longer in effect. The FTC wants these things to go away right away. Another pretty remarkable aspect of this proposed rule is that, as proposed, the rule would preempt or supersede state laws that allow non-competes. And what's so remarkable about this is that 47 states across the union currently allow non-compete agreements to be enforced in certain circumstances. And so the FTC is asserting that this rule will override the laws of those 47 states. I mean, the FTC's just never done anything like that before, so this is pretty remarkable. As proposed, the rule has one little exception. That's an exception for an employee non-compete agreement entered into in connection with the sale of a business, which is an exception that's pretty common in the law. In fact, California is one of the 3 states that does not enforce non-compete agreements, but even California will make an exception in the case of a sale of a business, because it's recognized that allowing a seller of a business to bind himself or herself to a non-compete agreement benefits that worker by allowing them to, realize the value of the business that they're selling. But as proposed, the FTC would only recognize that exception where the employee was a 25% or greater owner. So it's a pretty narrow exception to a very broad rule. One last part of the non-compete rule is that it would not go into effect immediately. Rather, they recognize that there would be some time needed to rescind existing contracts, reform existing contracts, notify affected workers. So as proposed, there's a 180-day implementation period. Next slide, please. They can't just do this immediately and have it take immediate effect. Rather, under the Administrative Procedure Act, the FTC, like any federal agency adopting a regulation, has to propose the rule and then allow members of the public to submit data, views, or arguments in support or opposition to the rulemaking. And beyond that, to the extent the FTC receives significant comments, the FTC has to respond to those. Doesn't necessarily have to accept the comment, but they have to think about it. And if there's an exception that can be made or a way to refine the rule to avoid some unintended consequence, they're supposed to at least consider doing so. As it stands right now, they call this the notice and comment period is open through March 20th of this year. Just yesterday, the Chamber of Commerce and other trade associations asked the FTC to extend that by another 60 days to May 19th. But as it stands right now, the notice and comment period is going to be open through March 20th. They've already received thousands of comments, literally thousands of comments, the great majority of which are pretty short, simple comments with people expressing their agreement, saying, hey, I signed a non-compete when I was young and I didn't like it. It deprived me of opportunity. Go ban it. That's the vast majority of these comments. There have been certainly comments submitted that are expressing the contrary view, and I expect more and more of those comments to be submitted as the notice and comment period continues. But so far, just numerically, the majority of the comments have been pretty short comments in support of a regulation. And what I want everyone on this call to take away is that if you want the FTC to consider your views on the non-compete rule, right now is the time to submit those comments. This is the last time the FTC really has to consider any concerns. Next slide. We could spend a whole hour on this, but the FTC's never done anything like this before. And so it raises the question, do they have this power? Do they have a statutory power under the Federal Trade Commission Act to engage in a rulemaking that overrides state law? And it's an open question. Now, the FTC is going to say that Section 6G of the Federal Trade Commission Act gives them the power to make rules and regulations to further their mandate of promoting or preventing unfair competition. And 50 years ago, 1973, a federal appellate court held that this rulemaking power is not just limited to the power to make rules of practice and procedure, but also includes the power for the FTC to adopt binding substantive rules. But that's a 50-year-old case. Congress has modified the law since then. Reading that case pretty closely, the court never said that the FTC can adopt any substantive law. They just said the FTC can adopt certain substantive laws. In fact, the opinion went out of its way to say that the FTC is hardly free to write its own law of consumer protection and antitrust. So suffice to say, we are in pretty unsettled legal waters here. There's some more exotic arguments. There's constitutional arguments, federalism arguments, the major questions doctrine. This is going to be litigated, and the outcome of that litigation is a big unknown at this point. Next slide. So going forward, nothing's going to happen immediately. Again, the notice and comment period runs through March 20th. I will expect that to be extended by another 60 days or so. The FTC is going to have to respond to all significant comments. That is going to take months at a minimum. But again, the chair of the FTC has a personal mandate from the President of the United States to do something to curtail the unfair use of non-compete agreements with employees. So my strong expectation is the FTC is likely going to adopt some final rule. That rule may include more exceptions and nuance than has been proposed, but I do expect a rule to be promulgated, at which point there's going to be litigation. The U.S. Chamber of Commerce has already thrown down the gauntlet that it will sue to challenge any rule that might be adopted, and it's going to take it all the way to the Supreme Court. But there could be other trade associations, individual businesses, states whose laws are being preempted might get into the mix. So it really is going to go up to the courts. But what's going to happen in the meantime, this is why I wanted to mention what the FTC did the day before adopting the proposed rule. In the meantime, the FTC does have an existing power under existing statutory law to sue companies that are engaged in unfair methods of competition. The FTC has some discretion in how they define what an unfair method of competition is. And the FTC for the first time ever, is now considering at least overbroad non-compete agreements to be an unfair method of competition. So I would expect more and more enforcement actions like that to follow while the rule is being ironed out and ultimately litigated. Next slide. There's one other antitrust development I wanted to share with this group, which is under existing law, it's Section 8 of the Clayton Act. It's a prohibition on what they call interlocking officers or directors. No person can simultaneously serve as an officer or a director of two separate competing companies. So simple example, you can't be CEO of one competitor and a member of the board of directors of another competitor. Bright line rule, you just can't do that. That's called an interlock. Now, that's a bright line rule. The statute's been on the books for over a century. It's just one of these statutes that hasn't been enforced very often. What I wanted to share with this group is the DOJ and the Federal Trade Commission are rediscovering this statute, and they particularly the DOJ have opened investigations into improper interlocks. And in fact, in October, the DOJ released a press release that they had been investigating interlocks among public companies, and in the course of that investigation, found 5 pairs of companies that had improper interlocks, and those 5 companies had members of their board resign rather than, suffer further investigation or litigation. But the government has not only refound Section 8 of the Clayton Act, but they're now pursuing rulemaking to develop further law. So the anti-trustification of labor and employment is certainly a trend to watch as we move forward in 2023. So with that, I'm going to pass this along to Caleb.
Thank you. Hi, everyone. So we're going to talk a little bit today about the pay transparency laws that we've seen coming up around the country. If you can hit the next slide, please. So around the country, there's been a growing trend in legislation intended to address historical pay equity issues experienced by women and minorities in the professional world. Pay equity laws are not necessarily new, however. Up until recently, pay equity laws were passed, but were largely limited to prohibiting employers from asking job applicants about their salary history or expanding pay equity protections based on sex to other protected categories such as race, age, and sexual orientation. These protections have evolved as we saw several states and localities enact pay transparency laws, which require employers to disclose salary ranges for open positions upon request by an applicant, or in some cases, a current employee. As I will talk about on the next slide, Colorado was the first jurisdiction to take this even further by imposing these salary disclosure requirements to public-facing job postings rather than upon request. Colorado's Equal Pay for Equal Work Act, which took effect on January 1st, 2021, requires employers to disclose in every job posting the hourly or salary compensation or a range of the hourly or salary compensation along with the benefits that come with the posted job position. The law also requires employers to advise current employees in Colorado of any job opening that may qualify as a promotional opportunity before the position is filled by an outside applicant. The compensation disclosure requirement applies not just to job postings for jobs physically performed in Colorado, but it also applies to any posting for a remote position that could be performed in Colorado, even if the company does not have any physical presence in the state. As a response to the law's reach to include these remote positions, many employers expressly excluded Colorado applicants from remote job postings. As you can imagine, this attracted pretty significant negative press and ended up making matters worse for some employers. As I mentioned before, this law was the first of its kind in that it required employers to make their salary information public through their job postings. While everyone can agree there are potential benefits to such transparency for workers, employers have a legitimate concern regarding their pay information being used by competitors when they're publicly disclosed in these job postings. In Colorado, business groups attempted a legal challenge on this and other grounds, but were ultimately unsuccessful. Next slide, please. Following Colorado's law, we saw New York City and New York State enact similar legislation. In New York City, the New York City Human Rights Law was amended to make it unlawful for employers in New York City to advertise a job, promotion, or transfer without including the minimum and maximum salary for the open position. Covered employers include those with at least 4 employees or independent contractors if at least one works in New York City. Unlike its subsequent state counterpart, non-salary compensation and benefits, such as paid time off and bonuses, may be omitted from such postings. Only current employees, not applicants, may bring an action against an employer for an alleged violation. Covered employers are subject to monetary penalties for the first violation if the violation is cured. However, but there is a cure provision where the violation is cured within 30 days. And we'll see a lot of these laws come up that do have these cure provisions, which are important. When it comes to remote workers, a non-New York employer must include a salary range in an advertisement for a remote position, provided the position could be filled by someone working remotely from New York City. By contrast, a job advertisement need not include a salary range if the position will be performed outside of New York City, even if the employer is based in the state. Switching over to New York State, which came after, the law will take effect in September 17th, 2023, and will apply to employers with 4 or more employees, which means only the smallest of employers do not have to comply. It applies to any advertising for any job, promotion, or transfer opportunity that can or will be performed, at least in part, in the state of New York. Job postings must contain either the actual compensation or range of compensation for the opportunity, a job description, if such one exists, and a general description of other types of compensation offered. For example, fringe benefits, bonuses, stock options, or commissions. The range of compensation means the minimum and maximum annual salary or hourly range of compensation for the opportunity that the employer in good faith believes to be accurate at the time of posting. Postings for any opportunity paid solely on a commission basis will comply with the law, provided it contains a general statement that compensation will be based on commission. Like the New York City law, it applies to any job that can or will be performed in the state of New York. For violations of the New York State law, employers are subject to civil penalties of up to $3,000. Aggrieved employees have no private right of action, but can file a complaint with the New York Commissioner of Labor. Next slide, please. So we've seen other states join this trend and in some cases take things even further. Let's start with Washington State. So in Washington, the state legislature amended its Equal Pay and Opportunities Act for the second time to require employers with 15 or more employees to include wage and benefit information in their job postings. This replaces the prior requirement that employers provide the information to applicants only upon request after receiving a job offer. Washington's pay transparency law is probably the strictest to date because it requires employers to post very specific details about benefits offered with a job position, like the number of paid holidays or other paid days off, and details about other forms of compensation, like discretionary bonuses or stock options that come with the position. The Washington Department of Labor and Industry, otherwise known as the DLI, recently issued administrative guidance regarding this law. One important aspect highlighted by the DLI is the requirement for employers to make these salary and benefit disclosures in postings for remote work that could be performed by someone in the state of Washington. Again, we're seeing remote workers being pulled into this law, these types of laws. Of course, it would not be a party if California didn't join. So in California, Senate Bill 1162, which also took effect earlier this month, requires employers with 15 or more employees to include a pay scale in all job postings. The law defines a pay scale as the salary or hourly range that the employer reasonably expects to pay for the position. The California Labor Commissioner has clarified that the pay scale must be included in the job posting if the position may ever be filled in California, either in person or remotely. The Labor Commissioner has also clarified that pay scale does not include bonuses, commissions, tips, or other benefits. However, if the position's hourly or salary wage is based on a piece rate or commission, then the piece rate or commission range the employer reasonably expects to pay for the position must be included in the posting. The pay scale must also be included in any third-party postings if a covered employer engages a third party to do so. For that reason, employers that hire third parties to handle job postings should consider adding an indemnity clause in favor of the employer to any service agreement. Pursuant to an already existing California law, all employers, regardless of size, must still provide the pay scale upon a current employee's or applicant's request. either for the position in which the employee is currently employed or for the position applicant is applying for. Senate Bill 1162 also requires employers to maintain records of job titles and wage rate history for each employee during the duration of employment and for 3 years after the end of employment. These records may be open to inspection by the Labor Commissioner. The penalties associated with not complying with California's pay scale disclosure requirements or the record retention requirements are anywhere between $100 to $10,000 per violation, with the caveat that no penalty will apply if an employer can demonstrate that all job postings have been updated to include the pay scale following their first violation. Other jurisdictions to enact similar laws have been Jersey City in New Jersey, Ithaca, Albany County, and Westchester County in New York. Next slide, please. In 2023, we're expecting to see some additional states and localities enact similar legislation. Connecticut is one of them. The Connecticut legislature recently proposed HB 5243, which, if adopted, would amend existing Connecticut law to require employers to disclose salary ranges in job postings. This would expand pay transparency requirements beyond those previously adopted by the state in 2021, which only required employers to disclose wage information for open positions to any applicant either upon request or when a salary offer is made. In 2021, Illinois amended the Illinois Equal Pay Act of 2003. Illinois employers with at least 100 workers must submit an application for an equal pay registration certificate to comply with this law by March 23, 2024, and then recertify every 2 years. To get a certificate, employers covered by the new law must provide detailed demographic and wage information about their workforce over the preceding year, including the workers' job titles, salaries, and other data. Businesses have to certify that the average compensation for their female and minority employees isn't, quote unquote, consistently below the average pay for their male and non-minority counterparts within major job categories, after the consideration of a variety of, quote unquote, mitigating factors, such as a person's experience, education, and the specific requirements of the job. Next slide, please. EEOC Commissioner Keith Sonderling confirmed that the EEO1 Component 2 pay data reporting will return soon, when he infamously warned recently, "Watch out, it's coming." The EEOC is charged with enforcing the Equal Pay Act of 1963, which requires equal pay for employees of all genders. In furtherance of this, the EEOC has previously used pay data gathered from employers' EEO1 Component 2 reports to assess the disparity in pay between employees of different genders until such reporting was halted in 2019. The EEO1 reports require employers to report information on employee compensation and hours worked, sorted by job category, federally identified pay bands, gender, race, and ethnicity. The EEOC views pay data collected through prior EEO1 Component 2 reports to evaluate gender-based and race-based pay disparities and released a comprehensive study last year examining pay data collected in those years of 2017 and 2018. The report demonstrated that the information gathered was useful, but needed to be supported by further short and long-term data collection efforts, hence the reinstitution of the reporting requirements. California has a similar pay data reporting law. In California, the pay data report requirements apply to any private employer with 100 or more employees. The law does not specify that those employees have to be employed in California, but defines employees broadly as any individual on an employer's payroll, including part-time individuals, and for whom the employer is required to withhold federal Social Security taxes. Employers must submit a pay data report to the Civil Rights Department, formerly known as the Department of Fair Employment and Housing, until it changed its name in July 2022, on or before the second Wednesday of May 2023, so May 10th, 2023, and on or before the second Wednesday of May for each year thereafter. In California, the law requires companies with 100 or more contract laborers to submit separate reports about employees' compensation to the state civil rights agency that detail median and mean hourly rates broken down by race, ethnicity, and sex for those workers. The penalties associated with not submitting the pay data report are up to $100 per employee for the initial failure to submit the report, and up to $200 per employee for any subsequent failure to submit the report. Next slide, please. So what are some solutions? Employers cannot avoid these growing state and local laws by including language in a job posting that excludes residents of a particular state or locality for an advertised role. As we talked about earlier, Colorado, we saw employers in Colorado try to do this, and it was met with a lot of negative press. Since then, a lot of the laws that have come out in these various states and localities have express provisions that prohibit this type of conduct. A job posting that identifies a salary or wage range for a position can include qualifying language explaining that where an applicant will ultimately fall within the stated range depends on a variety of factors, including, for example, geographic location and level of experience. We do recommend that employers conduct pay audits to stay on top of these laws. Employers should consider performing these audits to proactively assess their compensation practices across their workforce. The primary purpose of such an audit is to determine if outliers, like the examples above, while not occurring based on discriminatory intent, may statistically suggest or show a disparate impact on employees of color, women, or employees in other protected categories. So, having said that, I'm going to switch over to Caitlin.
Thanks, Caleb. All right, so switching gears a little bit, I'm going to touch on two laws that President Biden signed into law late December 2022 that apply to pregnant employees and nursing mother employees. Next slide, please. The first is the Providing Urgent Maternal Protections for Nursing Mothers Act, i.e. the PUMP Act. The PUMP Act has essentially two components for employer obligations, the time component and the space component. So for the time component, employers are obligated to provide reasonable break time for employees to express breast milk each time they have a need to do so. And that's for the 2-year period from the time that that need arises. The place component is that employers must provide those employees a place shielded from intrusion from coworkers and the public, which may be used to express breast milk. And that place cannot be a bathroom. If these obligations sound familiar, it's because the PUMP Act is really an expansion on some obligations that employers have faced since 2010 under the Fair Labor Standards Act. The FLSA, for short, applied only to non-exempt employees, though. So the goal of the PUMP Act and the effect of the PUMP Act is to expand the obligation to salaried employees, exempt employees, non-exempt employees alike who have a need to express breast milk. And it also extends the period from 1 year from the child's birth to that 2-year period that you see here. The place component remains the same. So the place that's not a bathroom, that's private for an employee to go, remains the same under the PUMP Act as it was since 2010 under the FLSA. Also remaining the same for non-exempt employees, these breaks can generally be unpaid. However, there's an important exception to that, as we all know that mothers are notoriously good at multitasking. An employee needs to be completely relieved from duties during the break period in order for it to be unpaid. So if an employee is responding to email on their phone while they're taking the break to express breast milk, it is no longer an unpaid break, fully relieved of duties, and must be paid. And of course, if there are salaried employees who are now encompassed in the PUMP Act entitled to this reasonable break time, the employer will not be deducting for those periods because salaried workers are paid regardless of how many minutes and hours they work. Next slide, please. Another key difference from what's been in place since 2010 with the FLSA is that the PUMP Act now provides a private right of action for employees. So an employee may file a complaint with the Department of Labor or against the employer in court alleging non-compliance with the PUMP Act's protections. An important caveat here, though, is that where an employee feels that they have not been provided a reasonable amount of break time or a space that complies with the obligations, they have to give the employer 10 days notice to essentially cure those defects and get into compliance with what's required under the law. Obviously, the intent of that is so that we don't clog the court system with claims of the break room being inadequate and what have you. But keep in mind that it is illegal under the PUMP Act to retaliate against an employee for requesting a break time or requesting a compliant space. And in the case of a retaliation claim, that 10-day cure period does not apply. So as we said, the major effect of the PUMP Act is to expand the reach of employees who are entitled to these protections. So it applies to almost every employee out there, with an exception of airline flight crew members who did get an exception carve out in the final version of the law. It also applies to most employers. So there is no cutoff for number of employees before you're obligated to comply with the PUMP Act. That said, for smaller employers defined as 1 to 49 employees, they may be able to argue for an exemption if they can show that the time and space requirements impose an undue hardship or significant difficulty or expense. That has not yet been fleshed out, but it's akin to what we are familiar with under the Americans with Disabilities Act, and which means it's a pretty high standard that you're going to have to show before you can legitimately argue undue hardship. Next slide, please. So on a practical level, what can employers be doing to ensure compliance with the PUMP Act? As you saw on the prior slide, these obligations, the time and space components, are in effect currently. They went into effect when the law was signed on December 29th, 2022. The enforcement piece, though, you do get a little bit of a leeway period. That's not going to be taking effect until April of 2023. So in this meantime, our recommendations are to ensure if you have eligible employees, i.e. employees who need to express breast milk, be assessing whether you have an acceptable lactation space. That's not a bathroom, private from other employers and the public, other employees, excuse me, and the public. And do you have a plan for a reasonable break time for these employees? That's going to mean a conversation with the employee as to when they expect they may need to take breaks to express breast milk. And it might mean shuffling some schedules depending on the nature of the employee's work to ensure that you have coverage that you need in place for the job while still affording an employee the break time to which they're entitled. We can expect to see some guidance coming out by the end of this month from the U.S. Department of Labor, the DOL, which will hopefully shed light and provide some examples of compliance. So descriptions of the type of spaces that will be sufficient, examples of how you can provide a reasonable amount of break time. And so we'll be on the lookout for that. But also communicate with your employees now. So making sure that your employees know that you as a management group, as an HR group, as an employer are aware of this obligation, intend to comply with it so that they're on board and that, you know, it's an internal check for you to make sure you have what you need to comply. And it also satisfies the obligation to let employees know that you are aware of this and that you have the space and time obligations anticipated to be provided. Next slide, please. So another new law that it was signed as the same day as the PUMP Act is the Pregnant Worker Fairness Act, or the PWFA. This one is a little bit more of a grace period. It's not going into effect until June of 2023, but it's a little bit more of a nuanced and a potentially heavy lift in terms of bringing yourself into compliance. So as of that date, covered employers have to provide reasonable accommodations to allow pregnant workers to perform the essential functions of their positions. Specifically, the standard is that you are obligated to provide reasonable accommodations for known limitations related to pregnancy, childbirth, or related medical conditions. Now, pregnancy-related medical conditions is a rather potentially broad and vague term, and it's not defined here. Known limitation is defined as a physical or mental condition related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions. And the key phrase for us here is whether or not such condition meets the definition of disability in the ADA. So as it stands today, it is illegal to discriminate against pregnant workers, at least from the federal law perspective. But what the PWFA does is bring that anti-discrimination mandate into an accommodation lens. So under the ADA, if a pregnant worker's condition doesn't necessarily rise to that high standard of a disability, you're not obligated to accommodate. The PWFA says if it's a known limitation and meets this more lenient definition, you are triggered an accommodation obligation. Next slide, please. So that said, in other ways, the PWFA is modeled after the ADA. It adopts the ADA definition of reasonable accommodation. It obligates employers to engage in the interactive process in the same way that the ADA obligates employers to enter a dialogue and have kind of a back and forth with employees regarding their accommodation requests. And it adopts the undue hardship standard that we were mentioning earlier under the ADA. So the obligation to accommodate a known limitation for a pregnant worker must be instituted unless doing so would impose an undue hardship. And an important note here that distinguishes the PWFA from the ADA's accommodation obligations is that leave, for example, maybe 30 days or 60 days or a temporary duration of leave, that sometimes could be a reasonable accommodation under the ADA, right? If your restrictions that you're facing as a result of a disability really don't fit with a job that we can provide at the workplace, under the ADA, it might be reasonable to say, okay, well, we're going to give you a 60-day leave, allow you to recover or rehabilitate or what have you. But the PWFA makes clear that leave can only be provided as a last resort type of accommodation, which means it behooves employers to be identifying, are there light duty jobs or tweaks that we could make to jobs that would allow a pregnant worker with a known limitation to stay at work doing something a little bit different. So in that sense as well, the PWFA goes a little bit beyond the obligations you see under the ADA, because if there's a temporary period that a pregnant worker with a known limitation might be unable to do those essential functions, the PWFA will step in and say, you still do need to accommodate absent undue hardship, where the ADA would say, well, can't do the essential functions, it's not a reasonable accommodation. So just be aware of how this is a little bit more nuanced and a little bit more expansive and taking it a step further than the ADA for pregnant workers with known limitations. Of course, retaliation is prohibited, so employees who make requests for accommodations, you cannot retaliate for making a request, and the PWFA, like the ADA, will be enforced by the EEOC. Next slide, please. So again, what can we be doing and expecting? You know, some of this might be, and same with the Pump Act as well, I should say. Some states have long held that employers have obligations to provide a reasonable time for breaks for expressing breast milk or for accommodating pregnant employees. So it's a matter of checking your compliance against applicable state laws, making sure that you're embedding an interactive process piece into your discussions with pregnant workers seeking accommodations, and of course, communicating with employees in the same vein as we touched on earlier with the Pump Act. Next slide. All right, I'm going to switch gears again, and I'm going to fly through a couple things to be aware of coming down the pike with respect to the DOL's proposed independent contractor rule. Next slide. So this got a lot of press late 2022, but we have not yet seen the final rule from the Department of Labor. So just for today's purposes, the idea is to be aware that soon we expect, maybe spring 2023, or at the very least sometime this year, an announcement from the DOL as the final independent contractor rule for the FLSA test to determine independent contractor status. Next slide, please. And again, we're going to be returning to somewhat of the familiar here, because the DOL's proposed independent contractor rule uses a six-factor economic reality test with the factors you see listed here. But that's really the same rule that we had under the Obama era administration for all intents and purposes. Under the Trump administration, there was a 2021 rule that took a more maybe concrete approach to the factors that are potentially decisive, and now we're returning to essentially what existed before that. So for employers, this might be more familiar and not the huge upheaval that some had anticipated with respect to the DOL's independent contractor rule. The factors, I'll just touch on them very briefly. Opportunity for profit or loss, investments by the worker and employer. So those two are obviously related. Do you have an independent contractor who's going out on a limb and representing themselves as being out in business for multiple different entities, or is it more of a traditional employee role? The degree of permanence of the work relationship, is this someone who has an indefinite relationship like most employees do, or is it piece by piece? And often the crux of the question comes down to control. So the nature and degree of control over the worker's duties on a day-to-day basis. But the keynote for people here, and what we expect to see potentially be more of a change, is that an employer's reserved right to control workers, which often comes up in like a staffing agency context, that alone could potentially be more decisive than it used to be. And so we recommend taking a look at any agreements you have where you might reserve control, even if you're not actually exercising it. Next slide, please. So again, no one factor is dispositive. That's the whole goal of going back to this totality of circumstances economic reality test. And we will be on the lookout for the final rule in May 2023. And Mark, I'll turn it to you.
I know we're running a little late, but I'm going to go quick. We have not yet gotten any questions in the chat. We will be able to stick around a little bit beyond one and take some questions if you have them. So now would be the time. As I mentioned at the outset, I'm going to be talking about changes in labor relations. It's become quite a dynamic in the American workplace because, among other things, workers continue to leave jobs at a very high rate. At the end of November, there were 10.5 million job openings. The largest number of openings gives workers more leverage in choosing jobs and negotiating pay and benefits. Surveys indicate that workers are frustrated with pay, benefits, and working conditions. And wage growth, although it's been quite rapid in the last 2 years, when you analyze it against the high rate of inflation, it's still not keeping up. Next slide, please. So there's been a very marked increase in union representation petitions filed, 53% in the last fiscal year, which ended on September 30th. And you can see the jump there in the first bullet. 2510 union representation petitions were filed versus 1638. Keep those numbers in mind. And these are filed by employees, unions, or anyone trying to seek to have the NLRB hold an election. And at the same time, we're seeing a great uptick in the number of unfair labor practice charges filed with the NLRB. Next slide, please. So what we're seeing is an increase in union organizing activity. It was well reported about the vote that the workers at an Amazon warehouse in Staten Island, New York, took to vote to unionize. At the same time, previously, there had been a vote in Bessemer, Alabama, where the Amazon workers voted not to unionize. And in December 21, we saw the start of a wave when workers at a Starbucks in Buffalo, New York, became the first Starbucks to unionize, and it started a tsunami. Because as you can see in the third bullet, 273 Starbucks stores have now voted to unionize out of 358 stores where election petitions were filed. Now, I went to law school because I'm not very good at math, but if you assume 358 petitions came just out of Starbucks, and you go back to the prior slide, you can see that big uptake in representation petitions. About 40% are simply Starbucks stores. Why so many? We can only presume that what Starbucks is doing as a corporate strategy is making them go store by store, making it harder for the union to have a coordinated win. It's very expensive, it's time consuming, but that is one typical strategy used when an employer wants to resist unionization. And the management, the CEO, has made it quite clear he wants to resist. Next slide, please. So at the same time, there's been a big uptick in strike activity, as you can see here. Nothing we've seen in almost the last 15 or 17 years. And the trend during the last few years is up. Next slide, please. So what we've seen, everybody is aware or should be aware that we almost had a nationwide railroad strike in December, and that was only avoided when Congress took some action and the president signed the bill. One very important distinction: the railroads and one other industry, the airline industry, come under the Railway Labor Act and not the National Labor Relations Act. The Railway Labor Act is very different in its schemes as to how it deals with strikes, and ultimately allows the federal government to step in and say, boom, there will be no strike, which is exactly what happened with the unions. Employers in the rest of the private sector that come under the National Labor Relations Act, that doesn't exist. But what was interesting was how the Biden administration, which is deemed to be pro-union, got behind the bill, which was not expected. Remember, the unions contend they helped get Joe Biden elected, and they're looking for a payback. We also saw a major strike at two major health centers in New York City, where nurses staged a 3-day walkout, which affected actually 16% of all the hospital beds in New York. Again, if you've been reading about or participate in the healthcare industry, you know that there's a lot of stress put on the workforce as we went through the COVID pandemic and other pressures on the healthcare industry. And it also has hit industrial workers in the heartland, as witnessed by the CNH industrial plants that went out on strike between May and January. And the wage increases that reportedly were settled upon after this strike are in the 25 to 30%, 38% range. Quite significant. Next slide, please. So Gallup does polls to see what the sympathy or feelings are of the American populace in general are towards unions. And you can see, according to a poll in August of last year, 71% of Americans now approve of labor unions, and it's been going up. And what are the reasons? I show them there in the Gallup chart: seeking better pay and benefits, employee representation, employee rights, job security, pensions, work environment, fairness and equity of work, health and safety, and a positive effect on the country being last. Next slide, please. Now, despite this, and this is the contradictory information, the rates of unionization in the total workforce are actually at an all-time low. Union membership, defined as the percentage of wage and salary workers who are members of a union, is 10.1% in 2022, and it's been going down statistically. What has happened here, despite all this organizational activity, is that the workforce has been growing at a faster rate. And that's why, and they've been growing in what are traditionally non-union jobs. But this 10.1% is the lowest rate since we've been keeping records on the federal level since 1983. Next slide, please. Now, when you have to draw a distinction between public sector and private sector workers, as you can see, the rates of unionization in the public sector are 5 times higher than what they are in the private sector. And again, public sector workers do not come under the National Labor Relations Act. They come under either federal law if they're in the federal government or various state labor relations laws. And among other things, many states prohibit the right to strike in the public sector. But the rates of unionization vary extremely widely based on geography in the United States. North Carolina and South Carolina continue to be the least unionized states in the country, but also among occupational groups. And I have some examples here. Educational training, library occupations, unionization rates being the lowest in sales and related occupations, computer, food prep, which would include most fast food workers, right? Despite Starbucks, the far majority of fast food workers in the United States are not unionized. And then management occupations. Next slide, please. So at the same time, we now have a National Labor Relations Board. Remember, the NLRB is composed of 5 members appointed by the president, but ratified by Congress. And the consistent practice, although this isn't written down anywhere in law, is that the president in power gets to appoint 3 members, and the opposition party gets 2 members. And that this only changes when a vacancy in the membership, when the term expires of a particular member. So we had, under the Obama administration, a board that was very active. Trump came in. He eventually appointed his 3 members. There was a rollback of a lot of activity. We're now 2 years into the Biden administration, and we now have a Biden-dominated board of 3 members over 2 Republicans. And they have been cranking out decisions that are pushing the law back to where it was under Obama and perhaps even further. I know 3 decisions came down in a matter of days in December. And most of these are 3-2 decisions with the Republican members dissenting. In the Thrive Company case, employers in violation of the National Labor Relations Act can be assessed with consequential damages. Historically, the only damages available to aggrieved workers were back pay and reinstatement. Now they're talking about greatly expanding the remedies, the financial remedies of what employees can get under the National Labor Relations Act. This case holds, it's really going to change the dynamic. Next case, American Steel Construction, made it easier for unions to participate, to try to organize what has been called micro units. This was the standard back in 2011 under the Obama board. The idea is that it's easier for the union to get into a small unit and then expand from within, if you will, rather than try to unionize a large workforce. And then finally, the Bexar County Performing Arts Center. This is a case that grants rights to non-employees to go on company property to organize. And it is again reinstated a decision going back to the Obama board that gives employees and third-party rights greater access to the work site. This is a performing arts center, and the center itself was not even involved in union activity. It was the symphony, I believe, that played there in the attempt to organize those. The symphony was just a tenant of the arts center. Next slide. Finally, where are we going? Well, we can see from what I've described that there is increased labor unrest and labor organizational activity. But if you drill down into it to look at where and what and the numbers, it seems to be limited to certain industries and certain geographic areas. If I was in retail, if I was in healthcare, I would be very concerned. Additionally, the NLRB is both judge and jury. The 5 members act as a jury, but the prosecutor is the general counsel, who was also appointed by Biden, Jennifer Abruzzo, and has been very active in undoing pro-employer decisions that came down in the past. the NLRB has issued a proposed rule on joint employment that would hold 2 or more employers, joint employers, if they share or co-determine. This again is not only a throwback to the Browning-Ferris decision that came down during the Obama administration. Many would argue it's going above and beyond, and expect the NLRB to issue a new fair choice and employee voice rule, which will make it easier for employees to speak out in the workplace and organize. Next slide. What should you be doing? Assess your level of risk based upon your particular industry, your geography, your workforce demographics, and other available statistics. One of which would be if I'm in a town or for example, an industrial park, I'd want to know what is going on with my neighbors. Be prepared for more aggressive union tactics. When the petition comes through the email from the NLRB, you have very little time to react. You have to think about what you're going to do before that petition comes. Truly understand what's in the hearts and minds of your employees. If wages and benefits are below market, try to do something about it. Unionized workers on average have 15% higher compensation, which includes benefits. Plus, if you're unionized, you will have additional administrative and legal costs to pay me and my colleagues to help you get through the process. Positive employee relations is not just about money and medical insurance. If you can't fix the wage scale or you can't fix the medical insurance, there are lots of other things you can do to improve employee morale. What we consistently see when people ask after the fact, why did the union get in here? One of the big issues is the weakness of first and second level supervision. They are your weakest link in this armor chain. And if you have that, you can fix that by training them and getting them on board as to what to do. Finally, unions are very effective at using social media. Hence, the poll you saw where the views of unionization in America have gone up from recent years. The question is, are you doing the same to persuade your workers they don't need a union? Next slide, please. And we are done. We went 10 minutes over. I hope we still have people listening. I'm looking in the chat room. I'll give it one last second. If you don't have any questions right now, please feel free to email us and we'll try to respond, but recognize we cannot give specific legal advice. With that, I'll turn it back over to Missy, but want to thank all of you very much for being attentive and joining us this afternoon. We continue to have these programs. Our next one is scheduled, I believe, in April, Missy, and we look forward to having you join us again. Missy?
Again, we value your participation, and in addition, we will be sending out a recording to today's presentation, as well as the PowerPoint itself to those that have attended and have not attended in the coming days. Thank you very much, and we wish you a great rest of your day.